State of Ohio versus Alexis Shelton, case number 25CR43258. Present before the court is Ms. Shelton, right?
Yes, sir.
Represented by counsel, we have Mr. Harrison, the prosecutor's office, Mr. Wilkerson from probation. We are here today for a hearing. Shelton, because your attorney has filed a motion requesting something called intervention in lieu of conviction.
Yes, sir.
We abbreviate this as ILC. If I grant this motion, which I'm inclined to do today, you're going to enter a plea of guilty to this charge, but instead of finding you guilty and imposing a sentence, I'm going to accept your plea of guilty and order that these proceedings be stayed for a period of 3 years. We're going to adopt a treatment plan, which at this point includes mental health counseling. You're going to follow the rules, and you're going to refrain from the use of illegal drugs or alcohol during the treatment period, and you're going to pay back the $1,200 in restitution. If you do all of those things, this case is going to end without a finding of guilt. But if you don't do the things that you're supposed to do, or you begin using drugs or alcohol, or you don't pay back the restitution, I can revoke the intervention in lieu of conviction and proceed to sentence. Do you understand that?
Yes, sir.
How old are you?
23.
How far did you go in school?
I did high school, and then I got my EMT certification from Sinclair.
Are you able to read and write English?
Yes, sir.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
No, sir.
Are you a United States citizen?
Yes, sir.
Other than what we have talked about, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No, sir.
I have a document entitled Change of Plea and Entry. It looks like on the second page there is a signature above the line defendant. Is that your signature?
Yes, sir.
Did you review this with your attorney before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
You're going to be entering a plea of guilty to one count of theft. This is a 5th-degree felony. It's punishable by up to 12 months in prison and a $2,500 fine. And if you violate the terms of your ILC, I don't have to send you to prison, but if I were to send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the ILC. Is that what you want to do?
Yes, sir.
Mr. Harris, has the state had the opportunity to consult with the victim in the case?
Yes, Your Honor.
Anything from the victim today?
No, Your Honor.
All right, what are the facts?
Your Honor, if this matter had proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about September 13th of 2025, the city of Mason, Warren County, Ohio, Alexis Shelton.
This case shows how the justice system sometimes focuses on rehabilitation rather than immediate punishment. Alexis Shelton admitted to taking $1,200 for photography services that were never provided, a mistake that could have led to serious consequences. However, the judge recognized an opportunity for her to correct her actions through intervention instead of a conviction. By requiring mental health treatment, restitution payments, and strict supervision, the court made it clear that accountability and personal growth must go hand in hand. While she was given a second chance, every condition attached to that opportunity carried real consequences if ignored.
Took $1,200 for services. These would be photography services that were never performed.
So, you got anything on the facts?
No, Your Honor. Thank you.
Michelle, did you hear those facts?
Yes, sir.
Do you admit that they are true?
Yes, sir.
Do you understand the rights you're giving up by entering a plea?
Yes, sir.
What's your plea?
Guilty.
I'm going to accept your plea of guilty. I think it's been made in a knowing, voluntary, and intelligent fashion only after you had been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm going to grant the motion for intervention in lieu of conviction and order that these proceedings be stayed for a period of 3 years. Again, we're going to adopt a treatment plan for outpatient mental health, and we have $1,200 in restitution. What I'm going to do, Ms. Shelton, is I'm going to put you into my 90-90 plan. That means that I'm going to impose 90 days in jail. I'm going to stay that 90 days for a period of 90 days to give you the opportunity to pay this. If you do pay this, then you don't have to do the 90 days in jail, If you don't pay this, then I'm going to put you in jail for 3 months. I don't care that you're about to have a baby or you're going to have a baby by then. You need to pay this or you're going to go to jail for 3 months.
Yes, sir.
When you get out, we're going to try again to collect the restitution money. If we can't collect it then we kind of give up, figure out what the appropriate penalty in this case is, and impose it. We do have two days of jail time credit, is that right?
Yes, Your Honor.
All right, we also have 2 days of jail time credit. You're going to be under the general supervision of the probation department. You're not on probation, but those are the folks that supervise my ILCs. And between now and the time you give birth, I'm going to continue to keep you on random drug testing. Anything else?
No, Your Honor. Thank you.
All right, that's all. Good luck to you, Ms. Shelton.
Thank you, Your Honor.
Thank you, Your Honor.
In the end, the judge's message was simple but powerful. A second chance is not a free pass. Alexis Shelton avoided an immediate conviction, but her future now depends entirely on the choices she makes over the next 3 years. The requirement to repay the victim, comply with treatment, and stay away from drugs and alcohol demonstrates that trust must be earned back through actions, not words. This courtroom moment serves as a reminder that responsibility and accountability can determine whether someone moves forward or faces much harsher penalties. Thanks for watching. Please like, share, and subscribe for more courtroom stories and shocking case updates.